there is a case you should know about. I think you probably have heard about it. This happened last May. All right. So a man named Daniel Penny, who was a college student, okay, was on the subway. And he encountered a man named Jordan Neely, 30 years old. Penny's 24. Neely was in the subway screaming things like, "Someone is going to die today," according to eyewitnesses. Okay? Now, Penny reached the rank of sergeant in the Marine Corps, so he knew what he was doing physically. He encountered Neely, got him in a hold around his neck, and Neely died. Alvin Bragg charged Penny, 24, again, former Marine, with second-degree homicide and other charges. And the trial is October 8th. Now, this has caused outrage in the city of New York, that he was tried for anything. But he has to go through the process. Penny does. But joining us now is Penny's defense attorney, Thomas Kenniff, law firm of Reiser Kenniff. A couple of facts about you, counselor. You took the case after a Go, Send, Go fund, Give, Send, Go fund was set up. It's raised more than $3 million, so you're getting paid. Your firm's getting paid. Nothing wrong with that. All right? But people were generous enough to help Daniel Penny. So as you go into the trial, it's going to come up fast, 6 months from now, less. Have you seen all the discovery in the case so far? Have you seen everything that the police have?
Yeah, at this point, we had very voluminous discovery. I'll point out that we originally took Mr. Penny's case on as pro bono because both my partner, Stephen Razor, and I are Iraq war veterans, and Mr. Penny being a Marine. And we set up the Give, Send, Go campaign within the firm. Of course, we could never know it was going to be as successful as it was. It wound up taking off and raising millions of dollars.
So you have not seen what Bragg's office is going to present, even though they had to present it to a grand jury. You're privy to that, right?
We were privy. I mean, we first of all, we saw the transcripts of the whole grand jury presentation, about 550 pages of testimony, from including about a dozen individuals who were on the train. And that was probably the most eye-opening thing.
Let me stop you there because I want to walk through this. Did any of the individuals in the subway car, according to the grand jury testimony, say that your client, Daniel Penny, was hostile, aggressive, should not have done what he did? Did they have witnesses that are going to come in and say, hey, Penny killed him and he shouldn't have done it?
They don't. The closest they have to that is one individual who has approaching 50 prior criminal convictions, had just been convicted and sentenced for bludgeoning one of his friends with a baseball bat about a year before.
That's all they have.
It was not in the subway car, but walked up
so they
as
have,
the incident was already. Yeah.
According to the grand jury testimony, they have nothing. They have nobody pointing a finger at your client. Why then did the grand jury indict?
So those who understand the grand jury process, and I've been practicing criminal law as a prosecutor and defense attorney for over 20 years in this city, the standard that a grand jury applies is reasonable cause. That's lower than the standard a police officer would need to summons you on the street for a petty offense. Moreover, a grand jury is comprised of 23 individuals. Only 12 of those 23 have to vote to indict, unlike a criminal trial where you obviously need a unanimous verdict. In addition, in a grand jury, the defense plays no role. The only time a defense attorney would be anywhere near the grand jury would be if the defendant is testifying, which almost never happens.
With 500 pages of testimony and no one pointing the finger at your client as being the aggressor or out of line here, it seems to me that it's almost impossible. But it is New York City, okay? And this is not really America anymore. Now, on your side, you're going to be able to bring in a bevy of witnesses, I assume. They're going to say they feared for their life, that they thought this Jordan Neely was a dangerous character, and that your client, Penny, did the right thing in protecting them. I assume you have that locked down, right?
Absolutely. It's overwhelming. I mean, it's locked down, one, because it's already been testified to in the grand jury, so no one could run away from it, not that they'd want to. And secondly, I mean, it's really going to be the district attorney. It's going to be incumbent upon them to call these witnesses. And if they don't, then obviously we have subpoena
Yeah,
power. So
you'll
we're not
call
going to
them
have any
as
issue
friendly
in that
witnesses.
regard.
Okay, how many people approximately do you have that are going to testify that Daniel helped them? How many?
There are, as I said, there are approximately a dozen witnesses,
A dozen,
give or take
okay.
a couple, that
So you
are going
got-
to,
I'm just trying to-
overwhelmingly.
I got it. So you
Testify that
have
this
in a
was one of the
court
scariest moments
going
in their life.
in October, 12 Americans that are going to say, we were afraid of this guy. He was at the level where anything could have happened. And you have one convicted felon who wasn't even on the train saying the opposite. So it seems to me that any district attorney faced with on the record, because all this on the record, would drop the case. Doesn't that seem to you that any honest district attorney would?
Particularly in light of what we've seen in just in the last few weeks, right? The incident in Brooklyn, before that, there were the shootings in the subways in the Bronx. And in the immediate aftermath of this incident, about a week later, there was a case in Brooklyn. You would hope, and I still have some hope that somehow, some way, cooler heads will prevail, and this case won't have to go to trial.
Could the judge in the case dismiss it before it goes to trial?
So we have already submitted and had the judge rule on motions to dismiss. They were denied, obviously, or we still wouldn't be here. But you have to remember, the judge, and I like the judge in this case. I've tried cases in front of him before. He's a very good judge, but he is constrained by the same legal standard that the grand jury is constrained by. So he has to review it based on that standard. And the old cliche, you can indict a ham sandwich. It may be a cliche, but it's pretty accurate. So, getting an indictment dismissed is next to impossible.
Remember, and I'm sure you do, Bragg pulled this in a bodega owner and charged him, and it was obvious because they had it on
Jose Alba.
Right, that the bodega owner was defending himself against an armed criminal. And Bragg charged him, Alba, but then dropped it because of the public outcry. And I think the public outcry on Penny is going to be even worse. Everything is expensive these days, you know that. The government is printing trillions of dollars and consumer prices higher than ever. If the government continues its printing and spending, the dollar could continue its free fall and lose its coveted role as the world reserve currency. Let's hope that doesn't happen. But there are a few things you can do right now. American Hartford Gold can show you how to protect your money, your retirement, your hard-earned savings against inflation by helping you diversify a portion of your portfolio into physical gold and silver. Start with a short phone call, and they can have physical gold and silver delivered right to your door or put inside your 401k or IRA. So please call or text them right now. Tell them Bill O'Reilly sent you. Call 877-444-GOLD, 877-444-GOLD, or text GOLD to 65532. Again, that's 877-444-GOLD, or text GOLD to 65532. Thank you for watching the No Spin News. To watch the full episode anytime on BillO'Reilly.com, please sign up to become a premium or concierge member. Visit BillO'Reilly.com to sign up and start watching today.